title companies, and real estate brokers. I'm attorney Vernita Williams. Welcome to part 3 of a 7-part series on how to sell the property of a deceased owner without wasting your time and ending up with nothing. We have all had those experiences. We worked very hard on a file only to find out it's not going to happen. You're not going to close. You're not going to make any money. And we want to alleviate that kind of thing. So maybe the reason is the owner of the property is deceased and you didn't even know it. Now you know, and now you have all of these folk you need to deal with to try to sell it. Well, this part 3 of the 7-part mini-series specifically talks about how to sell the property in probate. Now, I'm going to quickly go over 7 steps. The first step is you must determine the heirs. A lot of times, if you are a realtor or a title company or a real estate broker, somebody will say, well, I can sell it because the property is owned by my deceased father. And they're not telling you that they have siblings. They're not telling you that one of the siblings died and that they now must deal with the children of the deceased sibling. So first you got to determine who are actually the heirs that own that property. The second thing is, if it's a probate matter, and it will be if the owner is deceased, you need to appoint a personal representative in order to move forward and have a personal representative actually sign a contract. So the second step is get a personal representative appointed. Now sometimes this is easy because everybody agrees with one person, and sometimes it's not so easy because folk don't always agree. The third step is to get a signed contract. This is extremely important, and make sure the proposed buyer is really interested in the property. Make sure they have seen the property. Make sure they are capable of buying. Many times people will tell a realtor, I want to make an offer. They haven't even seen the property. When they see the property, they don't want it. They want to change the price. They want to do this. They want all kind of contingencies. So make sure you get a signed contract from someone who really wants to buy. Step number 4, prepare a comparative market analysis or an appraisal. If you're getting approval through the probate court, and these steps that I'm giving you will help you get approval to sell in a Florida probate court. If you're going to go to probate court, they want to see a comparative market analysis or an appraisal. They want to know that the amount that the person is buying the property for is fair to the beneficiaries. So don't think just because the person is dead and you got a motivated seller and a motivated buyer, don't think that they're just going to get the property for pennies on the dollar, even if the property is in foreclosure. So make sure step number 4, get that CMA or an appraisal. Step 5, go ahead and get a title commitment. Don't wait until you get court approval to get a title commitment, because guess what? The title commitment that talks about whether there are liens on the property, whether there's some big water bill that was left out there that nobody knows about, whether there's an open permit on property where there were repairs done that were not completed. You need to know all of these things from a title commitment, so by the time you get an order from the court authorizing the sale, you have straightened all the issues identified in the title commitment. So step 5, get that title commitment at the same time that you're working on getting a signed contract. Step number 6, prepare the petition for authorization to sell and file it with the court. Now, in Florida courts, normally they want to see a petition for authorization to sell. They want to see a comparative market analysis or appraisal. They want to see that signed contract, and they want to know that the heirs, the owners of the property, agree to the sale. And many times, depending upon which court you're dealing with, they want other documents like an affidavit of no estate taxes due or a statement regarding creditors. So make sure you're dealing with a probate attorney who understands that particular circuit court in the county that you're dealing with. The 7th thing is be sure to establish who is doing what. Many times, if you are selling a property of a deceased person and there are several beneficiaries, some of them may live out of town. So which of them have to sign documents? Sometimes all of them have to sign a warranty deed. Sometimes they expect the probate attorney to collect the warranty deed. Sometimes the closing agent collects the warranty deed. So everybody needs to be on the same page about who's doing what. So when it's time to close, nobody will say, well, I thought you were doing it. Well, I thought you were doing it. And it's not, something is left undone. So make sure, step number 7, everybody is clear on who's collecting those closing documents. So those are the 7 steps, briefly stated. There's a whole lot more into it. If you need more information, please call me. But in this 7-part series, there are other parts. Part 4, I will specifically discuss managing those heirs that can sometimes be kind of difficult. Part 5, I will talk about attorney's fees and realtor fees as it relates to probate property sales. Part 6, I will talk about timelines. Exactly how long is this going to take? In part 7, I will give a summary of the key points of all of the parts in this 7-part series. So if you are a realtor, if you are a title company, if you are a real estate broker, don't walk away from that deal just because the property owner is deceased. You can probably sell it, but you must evaluate what's going on very well to see whether it's worth your time. I can help you with that. If you need more information, please go to my website, vcwlaw.com, or you can contact me at 786-831-9483. That's 786-831-9483.